Here is a summary of the April 17th, 2025 Supreme Court opinion in the case called Cunningham et al. Versus Cornell University et al. Case number 23-1007. The question presented in this case is whether a plaintiff can state a claim by alleging that a plan fiduciary engaged in a transaction constituting a furnishing of goods, services, or facilities between the plan and a party in interest, as prescribed by 29 U.S.C. Section 1106, subsection A, paragraph 1, C, or whether a plaintiff must plead and prove additional elements and facts not contained in the provision's text. Justice Sotomayor delivered the opinion for a unanimous court. Justice Alito filed a concurring opinion in which Justice Thomas and Justice Kavanaugh joined. Please note that this opinion is read by an automated voice.
Justice Sotomayor's unanimous opinion. The Employee Retirement Income Security Act of 1974, ERISA, prohibits plan fiduciaries from causing a plan to engage in certain transactions with parties in interest. 29 U.S.C. Section 1106. A separate provision, Section 1108, subsection B, subsection 2, subsection A, exempts from these prohibitions any transaction that involves contracting or making reasonable arrangements with a party in interest for office space or legal, accounting, or other services necessary for the establishment or operation of the plan, if no more than reasonable compensation is paid therefor. The question presented is whether, to state a claim under Section 1106, a plaintiff must plead that Section 1108, subsection B, subsection 2, subsection A, does not apply to an alleged prohibited transaction. Petitioners represent a class of current and former Cornell University employees who participated in two defined contribution retirement plans from 2010 to 2016. In 2017, they sued Cornell and other plan fiduciaries for allegedly causing the plans to engage in prohibited transactions for record-keeping services with the Teachers Insurance and Annuity Association of America College Retirement Equities Fund and Fidelity Investments, Inc. in violation of Section 1106(1)(c). Petitioners claimed the plans paid these service providers substantially more than reasonable record-keeping fees. The district court dismissed the prohibited transaction claim, and the Second Circuit affirmed. The Second Circuit held that Section 1010(8)(b)(2)(a) is incorporated into Section 1010(6)(a)'s prohibitions requiring plaintiffs to plead that a transaction was unnecessary or involved unreasonable compensation to survive a motion to dismiss. 86 F. 4th 9 61975 held to state a claim under Section 1106, subsection A, subsection 1, subsection C, a plaintiff need only plausibly allege the elements contained in that provision itself without addressing potential Section 1108 exemptions. P.B. Schist Pitnotsit A, Section 1106A(1), C contains three elements. It prohibits fiduciaries from 1, causing a plan to engage in a transaction, 2, that the fiduciary knows or should know, constitutes a direct or indirect, furnishing of goods, services, or facilities, 3, between the plan and a party in interest. Its bar is categorical and does not remove from its scope transactions that were necessary or involved reasonable compensation. The exemptions in Section 1108 do not impose additional pleading requirements for Section 1106(1) claims. When a statute has exemptions laid out apart from the prohibitions, and the exemptions expressly refer to the prohibited conduct as such, the exemptions ordinarily constitute affirmative defenses that are entirely the responsibility of the party raising them. Meacham v. Knowles Atomic Power Laboratory, 554 U.S. 84, 91, 95. Like the exemptions at issue in Meacham, the Section 1108 exemptions are structured as affirmative defenses that must be pleaded and proved by defendants who seek to benefit from them. pp. 628. B. Respondents' contrary arguments are unpersuasive. First, the except is provided in Section 1108 language in Section 1106A does not incorporate Section 1108 exemptions as elements of Section 1106A violations. That reading ignores that Congress wrote the Section 1108 exemptions in the orthodox format of an affirmative defense separate from the prohibitions. Meacham, 554 U.S. at 102. The headings of the sections: prohibited transactions for Section 1106 and exemptions from prohibited transactions for Section 1108 confirm this understanding. Respondents also failed to explain why some, but not all, Section 1108 exemptions should be treated as elements of Section 1106A claims, yet requiring plaintiffs to plead and disprove all potentially relevant Section 1008 exemptions would be impractical, given that there are 21 statutory exemptions and hundreds of regulatory exemptions. pp. 9 do 12. C. Respondents' reliance on United States versus Cook, 17 Wall, 168 is misplaced. Cook established a rule of criminal pleading based on constitutional considerations not present in the civil context. United States versus Reese, 92 U.S. 214, 232. Even in criminal cases, it remains settled that an indictment or other pleading need not negative the matter of an exception made by a proviso or other distinct clause. Dixon v. United States, 548 U.S. 1, 13 pages. 12 Trinity. D. Finally, respondents' practical concerns about meritless litigation cannot overcome the statutory text and structure. District courts have various tools at their disposal to screen out meritless claims, including requiring plaintiffs to file a reply addressing exemptions under Federal Rule of Civil Procedure 7A, dismissing claims that fail to identify a concrete injury under Article 3, limiting discovery, imposing Rule 11 sanctions, and ordering cost shifting under Section 1132G1, pp. 13 to 15. 86F, 4961, reversed and remanded.
Concurring opinion. Justice Alito, joined by Justices Thomas and Kavanaugh, concurred in the court's opinion, agreeing that Section 1108 clearly sets out affirmative defenses that plaintiffs need not anticipate or refute in their pleadings under established legal rules and Federal Rule of Civil Procedure 8C. The concurrence emphasizes that this holding does not rely on the common law of trusts, as ERISA plans differ significantly from traditional common law trusts. While accepting the legal correctness of the court's ruling, Justice Alito writes separately to highlight serious practical concerns about its implications. He warns that the decision may enable plaintiffs to survive motions to dismiss merely by alleging routine and necessary business practices of ERISA plan administrators, potentially forcing settlements of meritless cases due to discovery costs. Although endorsing the majority's suggested procedural safeguards, particularly the ability to require plaintiffs to reply to affirmative defenses, Justice Alito expresses uncertainty about whether these measures will sufficiently address the practical problems he anticipates arising from the court's decision.
Interplay among opinions. Justice Alito's concurrence fully agrees with the court's holding based on what he describes as a straightforward application of established rules, regarding affirmative defenses. He explicitly joins the entire majority opinion based on the black letter law that plaintiffs need not plead affirmative defenses, as codified in Federal Rule of Civil Procedure 8C. However, Justice Alito writes separately to elaborate on his practical concerns about the court's ruling. He worries that the decision, while legally correct, will lead to untoward practical results by allowing plaintiffs to survive motions to dismiss simply by alleging routine business practices that ERISA plan administrators must employ. He particularly emphasizes the risk that defendants will feel pressured to settle even meritless cases due to discovery costs. While agreeing with the majority's suggested procedural safeguards, especially requiring plaintiffs to file replies to affirmative defenses, he expresses skepticism about whether these measures will adequately address the practical problems he foresees.